Hi everyone, this is Professor B speaking to you from my apartment as we all hopefully are self-isolating and trying to cooperate to help reduce the spread of COVID-19 and the coronavirus in our societies. I'm hoping that you are keeping well and doing your best to get through this challenging period. So as you know, classes have been suspended, and so we have no proper lectures, and we have to try our best to complete the semester to the best of our abilities and for all of us to successfully get through this lecture series. And so what I want to do today is I want to briefly talk about the last part of the evaluations for this lecture, and then I want to address the last piece of writing that you may be required to do for Human Rights and Social Justice, Laws 2105C. Okay, so now just a bit of administration. As you would have seen in the announcements I posted on CU Learn, I have changed the evaluation so the final grade will be based on the average of the best 3 reflection papers that you have written for me in the lecture series. So for some students, you might have written 3 papers and be satisfied with your grade, and I assume that all of you have received the grade for the 3rd paper at least by this weekend. But for some of you, you have the option to write a 4th paper, and that paper will be taken into account to determine your final grade. And so today I am going to talk about the subject of focus of that paper, and it will be about one specific part of Jeremy Waldron's long but wonderful article entitled Torture and Positive Law, a Jurisprudence Lesson for the White House. It is a very long article, and you will not be expected to read all of it. Instead, the final paper is going to be based on a specific passage taken out of the section that deals with what Waldron calls legal archetypes, and that's from pages 1721 to 1739 of the journal. Okay, it's of course only going to be a very small paragraph or passage that you will be expected to paraphrase and to then comment on, and I'm going to get into that specific part of the article shortly. I want to start by giving you some background to Waldron's article. You're already familiar with Jeremy Waldron because we have dealt with his piece on the relationship between human dignity and human rights. As you would know, Jeremy Waldron is perhaps one of the most prolific and influential political philosophers in the 20th century. He is a professor of law and philosophy at New York University Law School. He's also one of the participants in a seminar series on legal and political theory, one of my favorite series, the Dworkin-Nagel-Waldron Symposium for Political Philosophy. You can check online on the website for those of you who are legal theory nerds. Maybe there are 1 or 2 of you. I may have converted 1 or 2 of you into this interest. So Jeremy Waldron's ideas are worth taking seriously. The specific context for his article is the fact that post 9/11, in the wake of terrorist attacks on the World Trade Center, the Bush administration decided that in order to gain necessary information to fight the war on terror, it would have to contemplate the use of torture against those who may have information that could be used to thwart or prevent imminent threats of terrorism. If you have seen Zero Dark 30, it's a movie. It's a movie about how Osama bin Laden was ultimately identified and assassinated. You will see there are scenes of torture in that movie. Now, it's an open question as to whether torture produces any kind of useful intelligence. One of the major objections against the use of torture is that evidence produced as a result of torture is likely to be unreliable. But I think we need to be concerned not so much with the practical question whether torture works or doesn't work. We need to be concerned with the question of principle. Should we engage in torture in the first place? Waldron's answer to that question is no, and 1,000 times no. He is very clear that from a moral point of view, torture is morally objectionable. It is wrong. He makes the case that it is an absolute type of moral wrong. And he wants to make the case that torture is also wrong from a legal point of view. So we should not, as it were, mess with laws that prohibit the use of torture at the level of domestic law or at the level of international human rights law. I am going to focus on his reasons for thinking that the legal prohibitions against torture should not be undermined or weakened or limited and subject to exceptions. He does not think that the law is compatible with the idea of torture. He says torture is alien to the law, alien to the rule of law. It is antithetical or in opposition to the spirit of the law. Now, this phrase, spirit of the law, can seem like a vague metaphor. Waldron tries to make an argument to clarify what this claim might mean. What does it mean to say that torture goes against the spirit of the law? And it's this particular argument that I want to explain to you, which will be the context for the passage that you will deal with in the final reflection paper. Waldron develops a very interesting idea here. He develops the idea of what is called a legal archetype. He says that the legal prohibition against torture, laws that make it wrong to engage in torture, represent a legal archetype. He defines a legal archetype as, and you'll excuse me, I'm going to have to look at his article for this, a legal provision that makes vivid the point, purpose, policy, or principle of an entire area of law. You can find that on page 1723 of the article. Waldron's explanation of the idea of legal archetype means that a particular legal provision, and here let's explain what a legal provision is. It could be a constitutional provision. It could be a piece of legislation. It could be a case. Or it could be a legal principle or standard. Is a legal archetype because it displays and clarifies something fundamental about a specific area of law. In this case, Waldron believes that laws prohibiting torture clarify something fundamental about the rule of law. So the legal prohibition against torture is an archetype that tells us something about the character of the rule of law and its relationship to the proper use of force. Now, before I get into his reasons for taking this view, we should look at some other examples of legal archetypes. Now, a prominent example is the writ of habeas corpus. Habeas corpus is a Latin phrase. It means free the body. According to Waldron, the writ of habeas corpus exemplifies or illustrates a commitment to a deeper principle, namely the principle of freedom and liberty from physical confinement. The writ of habeas corpus is a legal archetype. So as I've mentioned in class, typically, if you have been detained by the authorities, by the police, you have the right to require the police to produce you before an impartial judge, and you have the right to require those who detain you to make a case to show that your detention is justified. And if they cannot make that case, then you can apply for a writ of habeas corpus to be released. So the writ of habeas corpus tells us something fundamental about the importance of freedom and liberty. Okay, and certainly in developed or consolidated liberal democracies like Canada, the idea of freedom and liberty is an integral part of our legal tradition. This is going to be important. It's an integral part of our legal history, our legal culture. And so the writ of habeas corpus helps to clarify the meaning and significance of the commitment to this principle of freedom and equality. Or if we want to go back to Rawls and we want to be fancy about the knowledge that we've acquired in this lecture, the writ of habeas corpus is a legal archetype because it expresses what Rawls describes as the principle of free and equal citizenship, where the paradigm expression of this principle is the freedom from physical confinement. Waldron mentions another example, the Second Amendment right to bear arms in the United States under the American Constitution. That is, the right to have weapons. He doesn't take a view as to whether or not this right is a good or bad thing in this article. He only uses the Second Amendment as an example of a legal archetype because it illustrates a certain attitude of permissiveness for the possession of weapons, which he explains as telling us something about the mythology or the folklore that surrounds the American political tradition. If you want to take a charitable interpretation of this view, it means that there is a link between the notions of freedom and equality that I mentioned a moment ago as part of our legal tradition, or the American legal tradition rather, and the right to bear arms is also a legal archetype because it expresses the mythological or folkloric significance of the principles of freedom and equality, which is why there is a more permissive attitude towards the right to bear arms in the American context. Now, both of those examples, the writ of habeas corpus and the Second Amendment, they are part of the American Constitution if we're thinking about the United States. He also mentions a third example, a case, a judicial precedent, and this is Brown versus Board of Education, where the Supreme Court decided that discrimination between the races is unconstitutional. It violates the principle of equal protection under law, under American constitutional law. Brown and Board of Education, of course, perhaps like Roe and Wade, okay, two very significant cases within the context of American constitutional jurisprudence. Brown and Board of Education, according to Waldron, is emblematic of a commitment to dismantle structures of segregation. So these are examples of legal archetypes. Okay, and so Waldron's claim now is that the legal prohibition against torture is also a legal archetype. So what we want to now do is to look at what he means when he says this and why he believes it's a legal archetype. How do you know that it's a legal archetype? And what makes it so significant? Okay. Now, to develop this argument, Waldron says, firstly, that the legal prohibition against torture as a legal archetype, okay, is emblematic of the principle of non-brutality in the law. What does it mean by non-brutality? If you recall in our lectures, especially the lecture on Kristen Rundle and the relationship between the rule of law and genocide, the possibility of an exterminatory legality, she argues that the legal subject is a rational and moral being possessed of dignity. Okay, it's the same idea that's at work here. Waldron says that there's a difference between persons and things under the law, and that when we use force in the law, because we know that the law involves the concept of punishment, restrictions, or even the removal of liberty. Okay, now all of these instances involve the use of force or the use of coercion. Okay, Waldron says that's part and parcel of the law, but when we think about the appropriate use of use of force in the law, we have to think about the use of force in a manner that is consistent with the respect of one's dignity. So there's a difference between people and things, okay? The law is not brutal in its use of law. So typically, if you're going to be punished, you're going to be locked up, you have to go through a fair trial where it has to be proven beyond a reasonable doubt that you have broken the law and committed a crime before your rights can be limited, right? There's also the idea that when people are prosecuted, they cannot be prosecuted on the mere say-so of others. Force cannot be exercised simply because those who happen to be in power would like to see you put away. There has to be an adequate process of justification where you participate in that process, and in so participating, your dignity is upheld. Okay, so the legal prohibition against torture is emblematic of law's commitment to non-brutality and is therefore fundamental to the notion that the legal subject is a rational moral being who's possessed of dignity. Okay, so how do you know that the legal prohibition against torture is a legal archetype, that it vividly displays and clarifies that a systematic part of our legal tradition is a commitment to the principle of non-brutality, the non-brutal use of force? Well, Waldron argues we know because the principle pervades a body of law, and we know that the prohibition against torture is a legal archetype if that prohibition figures prominently in legal arguments in some specific area or areas of law. Okay, so we look to the role and function of laws banning torture in other areas of law. To be clear, these other areas of law may not involve questions about torture. I'm going to get to that in a minute. The core idea here is that if something is a legal archetype and it clarifies a deeper and abstract point, purpose, policy, or principle in the law, it's going to generate something called gravitational force. That is to say, the weight we ascribe to the underlying value embodied by the legal prohibition against torture is going to gravitate outward and pervade, inform, and influence the way we think about other questions which may not involve torture, but that relate to questions about the use of force. And here, if we are worried about fundamental human rights, then one of the major reasons why we should worry about whether it's appropriate or not, let me rephrase that. One of the fundamental reasons why we think about human rights and the importance of respecting such rights is because we're worried about whether or not the use of force by the state in some given instance is or is not justified. So if that's true, if there's a linkage between the legal prohibition against torture and the value of non-brutality in the law, okay, the non-brutal use of force in the law, well, that means that the legal prohibition against torture is of utmost significance and will likely have a relationship to even other questions that seem distant from specific issues surrounding torture. The legal prohibition against torture is going to be relevant when we start to think about the proper use of force and whether or not force has been used properly or brutally in other areas. And that's what Waldron is getting at. Okay? So he gives a few examples of areas of law where the legal prohibition against torture arises as a relevant factor in the way we think about the proper use of force. So, for instance, under American constitutional law, there are legal prohibitions against the cruel and unusual punishment, right? And one of the major arguments that is often made in the case of cruel and unusual punishment is the idea that, well, under American constitutional law, there are legal prohibitions against torture. And because there are legal prohibitions against torture, which express a certain attitude about the proper use of force, that is the non-brutal use of force, okay, we can reason by analogy and say that when it comes to certain types of punishments, we should not allow those forms of punishment on the basis that they're cruel and unusual, because that would be in keeping with this commitment to non-brutality and the non-brutal use of force as evidenced by the legal prohibition against torture, right? Now, here, Waldron sets out a very interesting argument to try to practically bring out the problems that would arise if we were to, as he uses the phrase, mess with the legal prohibitions against torture. Okay? Now, he calls this the reverse slippery slope argument. Okay? So a slippery slope, well, is a slippery slope. If you stand at the top of the slope, there's a real risk you can slide all the way down. Now, as a mode of argumentation, what slippery slope arguments are meant to do is to say that if we accept the truth of some particular proposition, that's going to create problems, and the logically worst illustration of that problem, which is the bottom of the slippery slope, helps us to see why we shouldn't accept its truth. I know that's very abstract, so I'm going to try to get into an example here. Okay. Now, Waldron says, if you imagine that in the context of your system of law, you decide, or it has been decided, that the legal prohibition against torture laws banning torture, okay, should be weakened or made subject to exceptions so that in some instances torture might be permitted, well, that's the bottom of the slippery slope, right? That's your worst case scenario, that now torture becomes permissible, right? So he says, now, If that were to happen, of course, that's bad. But there are going to be these knock-on problems that arise further up the slope. That is, when we start to think about other questions that don't directly involve the use of torture, but involve questions about whether or not the use of force is justified. Questions around whether or not the use of force is brutal or not. His insight is, if we mess with legal prohibitions against torture, we open the door to the idea that the brutal use of force is, in some instances, justified. And if we accept this notion, that the brutal use of force will be, in some instances, justified, then this could create other problems that are damaging to our fundamental rights as we progress, as we further up the slope. Okay, that is, in instances where there are significant rights issues at stake, even if these issues do not implicate questions about, or directly implicate questions about torture. So let me give you an example. Suppose that you are detained by the authorities and subject to an intense interrogation where you are forced to confess to a crime that you may or may not have committed. Now, because the confession is in that sense non-voluntary, it's problematic. You are forced to confess. Suppose now the question arises in a criminal trial as to whether or not your confession could be used against you in a court of law. Your lawyer wants to argue that forced confessions are not permissible and cannot be used against you. If the legal prohibition against torture remains intact, that is to say, there are no doubts that torture is illegal in your legal system and accepted as illegal at the level of international human rights law, your lawyer could make the following argument, which is this: we should not accept a forced confession because it involves the brutal use of force. However, our law embodies the commitment to a principle of non-brutality, the non-brutal use of force. Force can only be deployed in a way that is consistent with the dignity of the legal subject. Why should we make this claim? Well, because we have ample legal rules that evidence this commitment. These rules prohibit the use of torture. Right? If torture is legally off the table, absolutely legally off the table, well, that demonstrates the strength of our commitment to a principle of non-brutality. And given the strength of this commitment to the principle of non-brutality, we should not allow forced confessions. Now, that's a very strong argument. And if you had been detained and you had been forced to confess, well, then that's the kind of argument you want your lawyer to be able to make. Waldron explains things look different if the legal prohibition against torture has been weakened or undermined. Now a judge might be able to say, hold on, it's true, our law evidences a commitment to the principle of non-brutality, but that commitment is not absolute, because in some cases torture will be allowed. Now, the judge's ability to engage this response substantially weakens the argument that your lawyer would like to make. It means your rights become far weaker in this instance. Now, this is the kind of worry that Waldron raises, and this is what he calls the reverse slippery slope, because the problems don't so much lie at the bottom of the slope. The problems arise along the slope. Okay, so we need to keep secure the legal prohibition against torture. Okay? Now, Waldron has much more to say about why it would be a bad idea to mess with the legal prohibition against torture. He makes a very interesting argument about, well, even if we suppose that the reverse slippery slope argument is subject to what he calls empirical refutation, so we can show, well, okay, we could still loosen laws prohibiting torture, it does not follow from this fact that if you were to make the kind of argument you'd like to make before a judge, the judge would then just open the floodgates to any use of force willy-nilly. He makes arguments about, he responds to those objections and so on and so forth. I'm not going to get into that. He also makes a case about how a legal system stands to lose its moral character in the same way that an honest person corrupts their character when they lie for the first time. Okay, he makes other arguments of that kind about the expressive or symbolic value of the legal prohibition against torture and the commitment to non-brutality. I won't get into that. I'm just going to make one last comment before I turn to the specifics of the paper that you will have to write. So hopefully you've watched the video this far. Okay, now I want to link all this back to the rule of law very simply, and to our discussions about human rights and social justice throughout this lecture, okay, or the series of lectures. So the core idea here, right, the core idea that is embedded in Waldron's argument, and that has been embedded throughout all of these lectures, is that the rule of law plays a fundamental role in shaping the way we think about moral questions of value and principle, as these relate to human rights and social justice. So we have an interest in protecting the deeper integrity of the law, the deeper principles of the law, which express this conception of the legal subject that Rundle talks about, a moral conception of the subject, as autonomous and as possessed of dignity. Okay, this idea that the legal subject is possessed of autonomy and dignity is the foundation stone to the notion that we are also free and equal, following Rawls, and the foundation stone to the idea that we are beneficiaries of certain fundamental human rights in virtue of our humanity. But the notion of humanity here has to be supported by and constituted by an adequate commitment to the rule of law. This is the worry that Waldron has, which is why he's so upset with lawyers post 9/11 who are trying to help the Bush administration to weaken legal controls against torture. Once you weaken these controls, this basic idea of the legal subject as possessed of autonomy and dignity starts to disappear. And when that happens, there's no difference between persons and things. And that becomes deeply, deeply problematic. Okay? So that's all I want to say about this idea of legal archetypes. I realize this is very brief, but I wanted to bring out this particular point. I think this is the most important point of the entire paper. I want to turn now to the specific part of the paper from which I will draw a passage for you to paraphrase and to comment on. It's on page 1735 of the article, which you have on See You Learn. Let me read out the general paragraph or part of the paragraph that I'm going to draw from, and I'm going to explain that paragraph to you. So when you think about how to paraphrase, okay, then you need to pay attention to what I'm saying here, okay? So, excuse my sniffles. It's just an allergy because my cat is sleeping next to me. I would bring her in as a guest, but she seems at this point to be pretty dead to the world. Okay, all right. So here's the relevant part of the paragraph. It comes about halfway down the first paragraph on page 1735. And the context for this passage is the argument that I explained a little bit earlier, the reverse slippery slope argument. Okay, so let me read. The idea is that our confidence that what lies at the bottom of the slope, torture, is wrong, informs and supports our confidence that the lesser evils that lie above torture are wrong too. Our beliefs that flogging in prisons is wrong, that coerced confessions are wrong, that pumping a person's stomach for narcotics evidence is wrong, that police brutality is wrong, may each be uncertain and a little shaky, but the confidence we have in them depends partly on analogies we have constructed between them and torture, or on a sense that what is wrong with torture gives us some insight into what is wrong with these other evils. If we undermine the sense that torture is absolutely out of the question, then we lose a crucial point of reference for sustaining these other less confident beliefs. I'm going to get you to comment on that passage. What is Waldron talking about? If you recall our first lecture on truth and value, objectivity, are there objective answers to questions of value in morality, politics, ethics, and law? I mentioned to you in that lecture that we cannot demonstrate the truth of our claims when it comes to claims of value. I cannot demonstrate to you the idea that torture is morally wrong. I have to make a case. I have to give you reasons. I have to justify my view. But none of these views will have the same level of certainty we might describe to some, say, claims in sciences or in physics or in mathematics or logic. 2 plus 2 is 4. Now that claim is an absolute, or at least almost absolute truth in logic and mathematics. The claim that torture is immoral is not absolutely true in the same way. It cannot be demonstrated. Okay? There's always, if you like, a furry edge of uncertainty. That furry edge of uncertainty gets larger and larger and larger when we talk about things like coerced or forced confessions, pumping somebody's stomach, okay, for evidence, or even beating or whipping someone in prison. Many of us might feel that this type of conduct is wrong, okay, but we cannot demonstrate that it's wrong. And our confidence in these claims is variable. It can vary. Okay, sometimes our confidence, as is the case with torture, can be quite high. Sometimes our confidence can be a little bit lower, forced confessions, and so on. Okay, so in cases of uncertainty, we need to have fixed points. We need to be able to reason from some more definite, considered conviction that we have about what is right and wrong, by analogy to instances where we are less sure and less confident. According to Waldron, the legal prohibition against torture, the absolute legal prohibition against torture, provides a fixed point from which we can reason by analogy to figure out whether or not some other lesser wrongs are wrong and why they are wrong. Okay? And so he says, all right, if we undermine the sense that torture is absolutely out of the question, then we lose a crucial point of reference for sustaining these other less confident beliefs. Because if we try to defend why in these less confident instances we might believe X or Y, we're going to use an absolute legal prohibition against torture as evidence for a principle of non-brutality to support our less confident judgments, right? So in that passage, he is talking about the crucial role that the legal prohibition against torture plays in justifying our perspectives about right or wrong behavior in instances where we are less confident about the rightness or wrongness of that behavior. That's the general point. So when you paraphrase this judgment, keep in mind the reverse slippery slope argument. Keep in mind the reverse slippery slope argument. Although you don't have to repeat the argument as context for any paraphrasing that you're required to do. That argument is for your information. It is the context to this particular claim, and I've laid it out. That's been the major focus of this video. Okay, I want you to paraphrase a part of this passage, which I will lay out for you in writing. I will post the relevant reflection paper question. Okay, well, by the time you see this, it'll be Monday, March, what is it today? 23rd. Yeah, Monday, March 23rd. And I'm going to extend the deadline for the papers, so you'll get 10 days. April 3rd will be the day when the papers are due. Okay. So to repeat, just at the point of administration, the final grade will be based on the best 3 out of 4 reflection papers that you wrote. It will be an averaging out of the best 3 papers. If you have already written 3 papers and you are satisfied with the grade, you are under no obligation to write this 4th paper. If you have written 3 papers, or in some instances I see some people have only written 2 papers, then it's in your best interest to write this last paper, okay? And then, as I mentioned, the grade is going to be based on best 3 out of 4. Okay, so I see we've gone, this is 34 minutes. I thought I would make some much shorter videos, but obviously legal philosophy requires lengthier treatment. So if you have any questions, you can email my TAs, or my head TA, Robnik, or you can email me. I will support you over the next 10 days until we're done with the semester. I really hope that you're able to find a way to productively use your time, since we're all supposed to be self-isolating at this point. It's a chance to work on some skills, learn some new knowledge, but also try to manage your stress levels. As I understand, the anxieties could be quite high. We have to be optimistic that things will resolve, but we also have to do our part. Okay, so in that sense, we should hope for the best, but we should take it day by day and do our part. Okay, so if you have any questions, as I said, you know how to reach me by email, and please look after yourselves. All the best.